2 years ago, a lot of tax practitioners were very concerned about several things that were going on in the property tax field. It mostly centered around assessor information requests. We had assessors who were issuing what we call 441D, RMT code 441D requests. And in those requests, they say, you are asked to supply information under 441D. We need the rent roll, we need this, we need this, we need this. And at the bottom of the letter, it always would say, if you do not supply this information, California law says you are guilty of a misdemeanor and you can go to jail. Well, people who read that, particularly people from not from the United States, who might have been from countries where they have civil law regimes, said, "Oh my goodness, I filed an appeal of my taxes. The assessor sent me this letter, and because I filed an appeal, I'm going to go to jail." And so what happened was we had taxpayers who were saying, they'd call up their lawyer or call up the tax agent and say, "Dismiss my appeal. I don't want to do this. I don't want to go to jail. Just because I appealed my taxes, I don't want to go to jail." Well, first of all, there's no authority for an assessor to arrest anybody and send them to jail. There's no authority for an assessor, show up to your door, "You know what? We asked for this information, you didn't get it. Guys, get the cuffs." But some overzealous assessors, and sometimes they were very low-level employees in the assessor's offices, were issuing these letters. And we complained about it, the State Board of Equalization, and the assessors said, "Oh, well, actually the assessors themselves, the State Board was in a turmoil at the time, said, "We'll police our guys, we'll make sure the guys don't do it." Well, that didn't happen. We still had these letters coming out from some counties saying, "Don't pay it, don't give us the information, go to jail." So we went to the State Board and finally got their attention and got them to do a couple of things. One is Rule 305 no, it's not even here. It's on the next page. In addition to those things, we were concerned about other due process violations that were occurring in assessment appeals proceedings. What we had was, in addition to just, you didn't give us the documents, you're going to go to jail, we had situations where people were standing ready to present their assessment appeal or called in before they could present their assessment appeal, and the assessor said, they were supposed to give us some documents, and they didn't. And then the boards were saying, "Oh, you didn't give the documents? Your appeal is dismissed," which is contrary to California law, absolutely contrary to California law. There are valid reasons for not giving information to assessors sometimes. And sometimes you don't even have it. So the first thing is we got Rule 305.2, no more of this hauling people in on special hearings, Rule 305.02, pre-hearing conferences, and saying, "Where's your documents? We don't have any. Your case is dismissed." Can't do that. That is illegal. Even if the taxpayer gets and says, "I don't want to give any documents. I'm sorry. I don't want to, just because I don't like the color of the assessor's hair." Well, then that's fine. Case goes forward based on the information that was presented. That's what's supposed to happen. Now, if the taxpayer then says, "Oh, well, here's that document you were asking for, Mr. Assessor," well, that's a no-no. That document doesn't come in. But the objective was, don't make taxpayers lose their appeal rights when they probably have legitimate reasons for why they're not providing documents. Most smart taxpayers will see an assessor needs a rent roll in order to figure out what this property is worth, perhaps. Those kinds of things are kind of important. The other thing we had is we had a variety of other due process violations that were going on, and we tried to get those actually specifics put into the rules. What we were able to get was a broad-brushed, but it's the first bullet point in Rule 302, AAB's function and jurisdiction, that all applicants are entitled to due process. Above all things, they're entitled to due process. And though it's not specific to a particular element of the proceeding, the taxpayer can now stand up and say, "Members of the board, number one item under your jurisdiction is to give me, the applicant, due process. I'm asking for due process now." It actually has changed the attitudes of some boards toward taxpayers. I'm going to skip over 305 because that was sort of technical. The other is Rule 323. We were having a problem particularly in LA County, but some other counties where their cases would come up for hearing. They were on calendar with a lot of other people. They didn't finish that day, and then they said, okay, well, we'll reschedule you. And then 15 months later, you get the notice, okay, we're back for the next day. And it's like, well, but one of the board members died. Well, okay, we'll just fill somebody in. No problem, just go ahead. And I actually had a case where this happened. It was, we did our first day, we got partway through the day, and I remember I asked the assessor for something, and she said, I don't have it. And they said, okay, well, we're done for today. I came back, next time I got scheduled was a year later. And I was in front of the board that time, and that was the day when the assessor decided to cloak the date. I'm going to talk about that in a minute. And one of the board members, who was a retired Superior Court judge, says, you can't cloak the data. That's like violates due process. That's illegal. And she says, I want a continuance. Gone for another year. Come back a year later. Finished putting on the case then. And then it's like, okay, now we have to have 6 months for findings. 4 years later, I get my decision. I'd spent $50,000 on a silly warehouse out of Pomona and attorney's fees, and I got a $50,000 tax refund because I had to keep getting up to speed and getting up to speed and getting up to speed, and it took 4 days to try a case that should have taken 1. I actually put this in front of the state board because I was so pissed, and the result was he got Rule 323 fixed. So now LA County in particular, but all the counties in the state cannot continue a case more than 90 days without good cause, and good cause is pretty specific. It's put a burden on the boards to do better scheduling, but it's helping taxpayers. The rest is stated. There has to be reasonable cause, and there has to be on the record, why did you postpone this? So I'm actually going to go in tomorrow. I've got a case. I've got a special administrator in a trust, an estate. The Superior Court judge is saying, would you get this done? Would you get this done? And tomorrow I'm going to go in, and the assessor is going to say, I want a postponement. And the board's going to give it to them. And I'm going to say, okay, they get their postponement because they're the assessor, but not more than 90 days because of the rule. And you know what? It's going to work. I'm going to, instead of getting, well, sorry, it's going to be Mr. O'Neill's 180 days or maybe 270 days, or whenever you get the notice, it's going to be 90 days. That's a lot of, taxpayers want certainty in these things, and that's really helpful. Next page, very quickly. This is what I was talking about, those letters. What we did was we went to the state board and we got them to write a form. So there's a cover page now that every county assessor, all 58 of them, have to use the same cover page. It states, and I have a copy here if you want to see one. It states what the law is. It clearly says that the assessor cannot send you to jail, so it tones down everything, and all the assessor has to do is then just attach the list of documents that he wants to the back of this form. It's streamlined things. It's going to end all of the haranguing of taxpayers. And we had to negotiate, work with the State Board of Equalization. The State Board of Equalization crammed this down on the assessors, and the assessors have agreed to it. So I'm very happy with the first one. The second one, assessors' use of confidential third-party information in assessment appeals board hearings. This is an insidious thing that goes on all the time now. Assessors have the ability to gather information that no one else can get. You know why that is? Because if your taxpayer has a change of ownership, the assessor could come to you and say, I'd like to see the purchase and sale agreement. I'd like to see the purchase pro forma. I'd like to see any appraisals that were used. I'd like to see any other documents related to that transaction. And then he'll say, and you can give me those to me because they're all confidential under Rev and Tax Code 451, and I promise not to disclose them because that's what the law says. So you give the jewels from the transaction, the pro forma that shows how you arrived at the purchase price, okay, which you spent hours, days, months putting together. Then what does the assessor do? Well, he's got another case, has a case come up, and it's a property that's like yours, but not yours. It's another taxpayer who's a competitor. And so he decides to put information on about that transaction, and so he takes the cap rate from your confidential pro forma, and he puts it on the list, and he shows it to everybody in the Assessment Appeals Board hearing. But he takes your name off of there, and he won't show the address of your property. I had this happen, hotel case. 7 hotels listed by the assessor, 7 cap rates. Oh, okay, well, I got 3, 6, 4, 9, 2. Okay, and you've got hotel A, B, C, D, E. Okay, so hotel A, if I knew what hotel A was, it would be a 9% cap rate, right? No. All I can tell you is hotel A is one of the 7 cap rates over here in this other column. What a joke. I cannot cross-examine that information. I cannot know anything about it. I look at assessment appeals boards and say, can you tell what this is? How much weight should we give this? This is a clear violation of, remember what I said? Due process. It violates due process. And you can't cloak it because there's a California Court of Appeal case, Chancellor Western versus Cook, which says you can't cloak it. Assessors are fighting us like crazy not to lose the power to cloak this data. And if you go into a $10 million apartment house and value up, you'll go into the hearing and you'll see they'll have lease rates from other apartment house sales or cap rates from other tilt-up warehouse sales, and they will have blacked out the names of all of those taxpayers or the addresses, and they'll show you the lease rate over here. That is illegal. And unfortunately, we don't have a resolution of this. We continue to fight it. Some counties, some assessment appeals boards, Riverside County said, it's out. Some boards in LA, out. One of the board chairs, who's an attorney in San Diego board, The other board member says, yeah, so what? So that's the range of cap rates. Who cares? Well, if I've got a hotel property and my hotel property is on the beach in Santa Monica, do you think we should use a cap rate from a Motel 6 in Carson?